Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. This appeal is directed against the judgment and order dated 29/3/1982 passed by the then learned chairman of the Motor Accidents Claims Tribunal at Ahmedabad in motor accident claim application, dismissing the application with costs stop. Para. In short, it is the case that on 29/9/1980 the appellant was riding the scooter stop. He and his friend were going towards Ahmedabad stop. The petitioner was driving the scooter while his friend was the pillion rider stop. As alleged, the appellant was driving the scooter cautiously, remaining on the left side of the road, keeping in mind the rules of traffic stop. He reached near a park at 4:30 p.m. stop. One truck at that time came from behind stop. Near park, he found muddy water flowing from one side to another, and so there was also a thin layer of wet mud on the road stop. He therefore slowed down the speed, took the scooter on the extreme left side of the road and stopped there. Stop. He continued to sit on the parked scooter. Stop. The truck which was coming from behind hit them from behind. As a result, both were knocked down and injured. Stop. The appellant was seriously injured. Stop. The truck driver was driving the truck at the hectic speed, endangering the human life. Stop. Soon after the incident, the appellant and another person were removed to the hospital. Stop. On receipt of the message from the truck driver, the police went to the hospital. Stop. The complaint against the truck driver was filed. Stop. The appellant had to undergo severe pains. Stop. He sustained heavy financial loss. Stop. In order to make the loss good, he filed the claim petition for compensation under the provisions of the Motor Vehicles Act before the tribunal at Ahmedabad and claimed rupees 6 lakh. Stop. Initially, the truck driver was joined as a party, but later on he was deleted. Stop. At the conclusion of the hearing, appreciating the evidence before him, the learned chairman of the tribunal reached the conclusion that negligence on the part of the truck driver was not established, and on that count the petition was liable to be dismissed. Stop. He accordingly dismissed the petition. Stop. It is against that judgment the present appeal has been preferred. Stop. Para. On behalf of the appellant, the learned advocate pressed the appeal upon the ground. Stop. According to him, the evidence on record was cogent and sufficient to hold that the truck driver was negligent in driving the truck, and because of his negligence the incident happened and the appellant sustained injuries. But the tribunal fell into error in appreciating the evidence. Stop. In the alternative, he submitted that negligence as the ancillary factor and ought not to have been given much weight in such cases. Stop. Para. In order to help the victims of the motor accidents, the Tortious Act, necessary provisions in the Motor Vehicles Act have been made so that they can get fair compensation and make the loss good, but the compensation is not to be awarded mechanically or as a matter of course on the happening of the incident. Stop. The party praying for compensation filing petition under section 166 of the Motor Vehicles Act 1988 dealing with fault liability has not only to allege the negligence on the part of the driver of the offending vehicle or vehicles or the other agency responsible in law to provide motorable facilities or facilities for the traffic and safety devices, but has also to establish the same leading necessary evidence, failing which he cannot succeed. Stop. In order to establish negligence, the party has to show what was the duty of the driver. The driver committed the breach of that duty, and the result of the breach of that duty was injury to his person and property. Stop. But let us make it clear that if the compensation is claimed under the principle of no fault liability under section 140 or on the basis of structured formula under section 163A of the Motor Vehicles Act 1988, negligence being not the essential ingredient is not required to be alleged or established. Stop.